In this talk, I will discuss about the Union Council of Ministers, the ministerial system, and the Attorney General of India. First, about the Union Council of Ministers. According to Article 74, Clause 1, there shall be a Council of Ministers headed by a Prime Minister to aid and advise the President. As the word shall in the Constitution means must, this clause means that there must always be a council of ministers around the President. There can never be a President's rule at the Union level. According to Article 75, the Prime Minister is appointed by the President and the other ministers are appointed by the President on the advice of the Prime Minister. Ministers are members of any of the two houses of Parliament or have to be one within 6 months of becoming ministers. Otherwise, they lose their jobs. The nominated members in either house are not usually appointed ministers, though there is no constitutional bar to it. By the 91st Amendment in 2003, the maximum strength of the Council of Ministers was fixed at 1/5 of the strength of the House of the People. Ministers may attend either House of Parliament and address it, but may not vote in the House of which they are not members. The ministers, including the Prime Minister, are administered 2 oaths by the President. First, an oath of office, and second, an oath of secrecy. Both laid down in Schedule 3 of the Constitution. The oath of office is, I, A.B., swear in the name of God, or solemnly affirm that I will bear true faith and allegiance to the Constitution of India as by law established, that I will uphold the sovereignty and integrity of India, that I will faithfully and conscientiously discharge my duties as a minister for the Union, and that I will do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. The oath of secrecy is, I, A.B., swear in the name of God, or solemnly affirm that I will not directly or indirectly communicate or reveal to any person or persons any matter which shall be brought under my consideration or shall become known to me as a minister for the Union, except as may be required for the due discharge of my duties as such minister. Emphasis has been added to certain words in the oaths of office of the President and the ministers for the Union to underline the point that whereas the President is oath bound to protect, preserve, and defend the Constitution, the ministers are oath bound to bear true faith and allegiance to the Constitution and to do right to all manner of people. It is within the boundaries of these oaths that the relation between the President and the Union ministers has to be understood. A further point of consideration is that the President does not take any oath of secrecy, presumably because the President is not privy to the information available to the Council of Ministers. Connected with this responsibility to the Constitution are the Prime Minister's duties. A. To communicate to the President all decisions of the Council of Ministers relating to administration of the affairs of the Union and proposals for legislation. B. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for. And C. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Please refer to Article 78. Along with the proviso to Article 74, Clause 1, this article is a moderating instrument against any ministerial haste and indiscretion, individually as well as collectively, but it creates a problem. Are the ministers committed to the oath of secrecy bound to communicate the President such information which they consider sensitive and not to be made public? As President is not bound by the oath of secrecy, passing of such information to the President may make it publicized. It is said at the height of tension between President Jail Singh and Prime Minister Rajiv Gandhi, the latter declined to communicate certain information to the former. The President could not secure it. However, if the President suspects that something is transpiring at the level of the Council of Ministers that threatens the constitutional edifice, she or he may insist on relevant information, and if the Council of Ministers declines to furnish it, the President will have the right to dismiss it at her/his own responsibility. Now, the parliamentary system. The ministerial system in India is also known as a parliamentary and a cabinet system. Parliamentary system signifies the responsibility of the Council of Ministers to Parliament. Until the 44th Amendment to the Indian Constitution, the word cabinet was absent in it. However, the Council of Ministers always was stratified into three ranks by the rules of government business. cabinet ministers, ministers of state, and deputy ministers. The 44th Amendment inducted this word into the body of the Constitution. Refer to Article 352, Clause 3. And this amendment also defined it as comprising the Prime Minister and other ministers of cabinet rank appointed under Article 75. The cabinet, therefore, may be treated as a committee within the Council of Ministers. Within the cabinet, committees have been set up like the Cabinet Committee on Political Affairs, the Cabinet Committee on Economic Affairs, and the Cabinet Committee on Defense, in which ministers below the cabinet rank are sometimes included. Ministries, including the secretaries, are supposed principally to be parts of the government. Under them are the departments which actually run the administration. Which department will be under which ministry depends on the rules of business issued by the president, but actually framed by the prime minister. The placements have to be rational as a whole, but personal, factional, and coalitional considerations often influence such decisions. There are, for example, ministers of estates with independent charge of departments. Ministers should be members of either House of Parliament at the time of assuming office or within 6 months of it. There is no constitutional bar to the reappointment of a minister who has failed to come to any of the houses after a day's gap. But that is considered bad practice. Each ministry has a secretariat composed of civil servants who are expected to be politically neutral so that they may serve governments run by alternating parties without fear or favor. The cabinet has its own secretariat headed by the cabinet secretary, enjoying the status of the topmost civil servant of the country. Now, the President and the Council of Ministers. The constitution makers of India chose to write out the provision for ministers only partly and left the actual working of the system to conventions. Article 74, Clause 1 simply provided that there shall be a council of ministers to aid and advise the president in the exercise of his functions. The preeminence of conventions was upheld by Article 74, Clause 2, which said that the question whether any, and if so, what advice was tendered by the ministers to the president, shall not be inquired into in any court. It was understood as a matter of convention that the president in all her oblique his functions would be guided by the advice tendered by the Council of Ministers alone. that the advice of the Council of Ministers conveyed by the Prime Minister would be binding on the President. In the Shamsher Singh versus the State of Punjab case in 1974, the Supreme Court accepted this position unequivocally. That made all the powers of the President, except the power to appoint the Prime Minister, actually vested in the Prime Minister and his colleagues. It was also realized that a council of ministers could always force the hands of the president by the threat of resignation. By the 42nd Amendment, much of it was formalized. It was laid down by a proviso added to Article 74, Clause 1, that the President can ask the Council of Ministers to reconsider and advise but once. And the President has to act according to the advice submitted after reconsideration. There is no limit to the amount of time that the President may take to send back an advice and to accept the advice, a phenomenon known as the pocket veto. It may effectively kill an advice, as during the time of such transaction. First, the utility of the advice may lapse. Second, the Council of Ministers may be compelled to resign. And third, President may dismiss the Council. Now, the Attorney General. Although government has its Ministry of Law, its chief legal advisor is the Attorney General. The President appoints a person qualified to be a judge of the Supreme Court as the Attorney General, who holds office during the pleasure of the President. He is a part of the Union Executive, and his duty is to advise the Government of India in legal matters, to discharge the duties of legal character assigned to him by the President, and to perform such duties as are conferred on him by the Constitution or any law for the time being in force. He has the right of audience in all courts in India and to speak in and otherwise take part in the proceedings of the Houses of Parliament separately or jointly. In brief, this is about the Union Council of Ministers, the ministerial system, and the Attorney General of India. Here ends the discussion on the Union Executive. In the next talk, I will start discussion on the Union Legislature. The understanding of the Union Legislature would be very necessary for understanding of the delegation of financial power rules and general financial rules. Therefore, you have to give a special attention to the discussions which will follow. Thanks for patient listening.